Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the LexRex Institute podcast. I'm your host, David Truschel. Now you say your part, or I can say it
You're
for you.
supposed to say you're the lead writer for the LexRex Institute,
Yeah,
David.
you've been complaining about how long this section takes. I was trying to do a little editing, but whatever.
Well, then I didn't know that my part was supposed to come in.
Well, that's why, the pause, the pregnant pause.
Oh, well, I'm your co-host, Alexander Haberbush.
Yeah, that's right. Anyway, before we begin, please note that nothing in this podcast constitutes legal advice. He is an attorney, but he won't be speaking as one today, and some other stuff, like this is about law, not about politics. Learn the difference, all that stuff. We've done this 1,000 times before.
So is that, I think last we spoke, we were going to put up a poll on whether or not you wanted to have an etymology section of this podcast. Have you seen the results on that yet, David?
Well, I thought you were joking, so I didn't do that. But having learned today that you weren't joking, I just put it up. So unless something goes wrong, people.
I see there's already a yes vote.
Oh, did you do that?
No, I can't. It appears I can't vote on this.
Okay. Well, let me
Now I can.
Let me go register.
All right, there are 2 yes votes now.
As discussed, I will be voting no. So let me do that real quick before this gets out of hand, and people won't vote no because they think that the writing's on the wall. Need to prevent that from happening.
And just for those who are not aware, etymology is different from entomology. This is not going to be a section about insects. It's going to be a section about words and their origins.
Oh, I can't vote no. I assume because I created the poll. So
I think you probably can. I think you have to switch your account from LexRex Institute to David, right at the top right of the page. That's what I had to do.
Oh yeah, there you go. Yeah, I thought that it worked a little differently since it wasn't like the main page, but apparently, all right. So, but anyway, my no vote has been registered. So currently 2-1. Yeah.
Hopefully they find you some extra ballots at 2 a.m.
Well,
that can sway the tide for you.
All right, I was gonna go with a very different kind of get out the vote joke. You went in that direction, and that's okay, I guess.
Yeah.
Well, anyway, before we get completely into the program, I've been waiting to tell you about this because it just happened on my way home today from the university. I encountered another excessively French individual, but of a very different type this time. It was a young man walking with a girl, I assume was his girlfriend or wife or something. Anyway, last time around, I mentioned that the guy, sort of wearing a beret, waxed mustache, smoking a cigarette, that kind of a French guy like you might see in, I don't know, an early new wave film or something. In this case, much more sort of like a French punk type, wearing like an overcoat but with combat boots and a satchel over the shoulder and a ponytail that came to about mid-back. And yeah, I didn't realize that the old alliance between Scotland and France still ran so strong that
You met a genuine Eurotrash person, it sounds.
Yeah. Anyway, not really much more to that story. I heard him speaking as well, how I know he's French or possibly Belgian, but we'll set that.
I'm glad somebody like that was able to find a significant other that shares his interests. That's good. Good for that person.
Yeah. Anyway, with that out of the way, that little snapshot of life in Scotland, I guess. Well, we got a couple of things to talk about tonight. One of which, and we'll get into that next.
I'm laughing because we actually had probably a 10-minute conversation before this podcast where we said, what the heck are we going to talk about?
Yeah, well, we have an answer. A while back, we talked about this law when it was originally drafted and then originally challenged in court, but the Texas social media law that we talked about a few months back, House Bill 20 in Texas, has been upheld by the Fifth Circuit Court. Not necessarily the final word. It could still go to the Supreme Court. Probably will, to be honest. But Circuit Court has weighed in, and they've found in favor of Texas, basically. So you may remember that this law had to do with preventing large social media companies. That's an important part of this. It's not any random service provider. It has to be of a significant size. I forget exactly how they define that. I think so many hundreds of thousands or millions of users or possibly revenue. I don't remember. You may.
Debauch count.
Thank you, Mr. Musk. Anyway, so the law would impose certain conditions on large social media companies, however that's defined in the bill, to be very transparent about the way they go about moderating posts, the statistics around their moderation of posts. They would have to make reports about, like, oh, we got this many comments reported, we actually deleted or suspended or did whatever on this many of them.
Now we talked on this show about the Florida law.
Yeah.
It sounds like it did something similar, and we'll put a link to that episode in our description.
Yeah.
But was this Texas law substantially the same as that?
It's certainly in what it's aiming at, I would say. I don't think that the sort of schema for imposing penalties was exactly the same. And I think in this case, at least the opinion of the court made it sound as though it was really after injunctive relief rather than damages. I'm guessing there's probably damages somewhere in the bill, but it seems like that was de-emphasized at least.
Well, I think that was true in Florida as well. Although I think the Florida law seemed to be targeted not exclusively, but certainly predominantly at candidates for office and not censoring those candidates.
Right.
I don't think that's true with this Texas one.
No. And in the Florida case, it imposed pretty hefty fines for people who did, as it defines it, sort of deplatform political candidates, like tens of thousands of dollars per day, I think, was the penalty.
Yeah, they're not going to pay that.
No.
It's not even clear that Florida courts would have jurisdiction over those social media companies.
Yeah, and so we'll probably get into that in a minute, the jurisdiction issue of it. But probably the most obvious feature about this ruling, to my mind anyway, and you can, share your thoughts on it in a minute, is that they came out very plainly, very clearly, explicitly said, yes, large social media companies are common carriers. We talked about that previously, but common carrier is, something like, parcel delivery or mass transit, things where basically it's just there to serve.
Trains.
Yeah.
Planes. That's the reason why airlines are federally regulated. The reason why an airline has to, here's a good one. The reason why they used to be required to allow those Hare Krishna guys to proselytize in airports was because airlines were common carriers. So they couldn't prohibit people from expressing religious beliefs, free exercise of their religion in airports because they were subject to First Amendment protections, the way that a private company, a purely private company, would not be. Yeah. So they're basically treated as a quasi-state actor because they're a common carrier. Obviously, now that we have TSA, all the post 9/11 stuff that's in effect, that's kind of caused that to evaporate because people aren't congregating in the parts of the airports. You're not in the parts of the airports very long where you could actually go without having an airline ticket. So that's a different issue. But they could technically still be there. There's just not really any reason to. When
you could be like at the ticketing counter, I guess, or in front of the ticketing counter.
Yeah, although they'd probably say that you're blocking like a public thoroughfare if you did that. So I don't know. But
yeah. But anyway, yeah. So
so if you're older than like 30, you'd probably remember that. If not, then sorry, nothing on the top of my mind that comes to mind about what you might know at an airline.
Yeah, but so the upshot was Texas was arguing that companies like Twitter and Facebook should be treated as common carriers, meaning they would be, required to sort of maintain viewpoint neutrality. Basically, they couldn't edit posts or arguably manipulate the algorithms so that you can't see posts.
Can't engage in viewpoint censorship.
Yeah.
Yeah, that's broadly speaking, can't censor viewpoints they don't like.
Yeah, based specifically on the content of the post. With exceptions for things that would run afoul of obscenity laws or, otherwise be illegal for other reasons.
Sure.
But
fighting words.
Yeah, sure. And as you
clear and present danger, stuff like that. If you don't know what the limitations on free speech are, go ahead and check out our Ask an Attorney video from last week featuring my sister Vanessa Haberbush on fighting words and other things that may technically be free speech, but you're certainly going to be held accountable for those things if you do.
Yeah. Basically, an industry group representing a lot of these tech companies banded together to challenge this, saying, no, we are not common carriers. We are private companies. We're entitled to First Amendment expression, just like anybody else, including editorial viewpoint expression.
And just to be very clear, the Supreme Court has never recognized that social media companies are common carriers. Justice Clarence Thomas, about a year ago, kind of intimated in one of his, I think it was the opinion that he wrote on a petition for cert, actually, I'm forgetting which case, but kind of intimated that the court may go that direction with social media companies. They have not done that to date. So as it stands currently, every jurisdiction in the United States, every federal jurisdiction in the United States, social media companies are not regarded as common carriers.
Yep. So as you mentioned, sorry, we had to take a bit of a break there because of some loud sirens in the background. So apologies if this is a little disjointed, but you were just saying Supreme Court has never recognized social media companies as common carriers. That didn't seem to put off the Fifth Circuit Court too much. They don't make it the exclusive basis of the judgment, but the decision does say, and I'm quoting, "Our decision is still further reinforced by the common carrier doctrine, which vests the Texas legislature with the power to prevent the platforms from discriminating against Texas users."
Yeah, further reinforced is putting it mildly, I would say. I think they have trouble reaching the conclusion they do without recourse to common carrier doctrine.
That was my impression, certainly. Yeah, and it seems that much depends whether you take that in one direction or the other, because the opinion is full of statements about what the platforms are trying to ask us for is actually a right to censor, not a right to speech.
Right, which those arguments really, those beg the question.
Yeah.
If social media companies are not common carriers. So question begging, we've talked about that before.
Yeah.
That means basically reasoning in a circle where your premise is the same thing as your conclusion. Well, the only way that curating content on a social media platform, the only way that would constitute censorship rather than speech would be if it's not actually that platform's speech that we're talking about, but
right.
the user's speech that we're talking about. And the only way, in my mind, that actually becomes a relevant consideration, the way that we start talking about the user's speech instead of the platforms, is if they're a common carrier.
Yeah, because a common carrier, the service they're providing is just the transit, basically. It's
a way of transmitting people.
Yeah.
Or thoughts or ideas
exactly.
or items, whatever it is.
So they're taking your words and they're putting it somewhere else, namely on the internet, and other than that, they're not involved. They don't offer services. That's what the common carrier model would mean for them. And in that case, any interference they make would be, or at least could be conceived of as censorship.
Now, on the other side of things, there is Supreme Court precedent basically saying words to the effect of more speech is better than less.
Yeah.
We ought to encourage more speech. So I would say that there is some argument, something to be said for the censorship versus speech thing, even if they aren't a common carrier, just because what they're doing by nature is limiting the amount of speech on their platform. Now, I think there's obvious limitations to that more speech is better than less doctrine. Anybody who's been to a party with a guy who just insults everybody and says a bunch of offensive stuff the entire time knows full well that they would have been better off if that guy had said less. Right?
Yeah.
So, I mean, more speech better than less may be a general maxim, but it's not something that's going to be dispositive in a case, right? You're not going to find in favor of one party or the other just because more speech is coming from one side. I think that's kind of an absurdity. And that's not really what the court does here. But I would say that there is something to be said for that side of the argument, even absent the common carrier doctrine.
Yeah. And, as I think we discussed at the time this issue first came up, there may be good reason to consider social media companies to be common carriers. I certainly don't feel strong in my opinions about it. I don't know enough about that. But, if on the far side, though, that is the decision that comes down, that would obviously change things significantly. But
well, you want to know my opinion on it?
Sure.
And that's why I'm here, right? Give legal opinions
exactly.
and whatnot. I think that it very well might be the case that certain social media companies function as or behave as common carriers and therefore ought to be treated as common carriers. I don't think that's a numbers thing. I don't think the mere fact that a social media company has a certain number of users means they're inherently acting as a common carrier.
Okay.
I think it's going to be based on the way that they behave. Well, look at Facebook as an example. People use Facebook for company pages. We use it for our company page. We have a big presence on Facebook. People use Facebook to plan birthday parties. They'll have events on Facebook. You can invite all your friends to your events.
Yeah.
They use it to post family pictures from vacations, stuff like that. That to me suggests people are using this to coordinate social activities in which they are already engaged prior to going on the internet. Even if the internet didn't exist, people would still do this same basic stuff. They would just do it less efficiently, right? They might do it person to person. They might do it by mail. They might do it by phone calls, whatever. It's the same stuff they're doing on Facebook. Facebook is facilitating those kinds of interactions. That, to me, is the sort of thing that a common carrier does. Now, on the other hand, look at TikTok. Now, I don't really understand what TikTok is. I know the kids like to use it. It seems kind of dumb. But I guess it's kind of, you just record pictures on your phone and you send them to all your friends.
Videos,
Now,
but yeah.
Yeah, videos, sorry. Now, debatably, you may disagree on this. That's fine. But the point I'm really making is this stuff is up for debate. It's not something that ought to be decided purely on a numbers thing. So, debatably, TikTok is creating actually a new social activity people weren't doing previously.
Yeah.
It's when you make these videos, you put cat ears on yourself, you put filters on them, you have these transitions, so on and so forth. That's creating a new service that didn't previously exist, with ways of facilitating friends interacting on this stuff that is new. That's not, it's a product more than just a way of facilitating human interaction and communication that was pre-existing. Now, I'm not saying that's the case. I'm saying that's debatable.
Yeah.
You could make that argument. And I'm sure there's a variety of other social media platforms. You could argue that something like eBay is a social media platform because you buy stuff, you leave seller feedback, the seller leaves buyer feedback. Those are social media components to that. Is eBay providing a product that is more than just facilitating commerce in people or things? I don't know. It's debatable. But my only point here is it's certainly not a numbers-based determination. It's a fact-based determination.
Yeah, I think that makes sense. Are you providing anything other than just sort of a channel for information to pass through, or is what you're doing actually contributing something new to it? And I think, I think certain platforms, that is the case. As, TikTok, I think, was a good example because it sort of tends to incubate, as near as I can tell. I'm a millennial. I'm not one of these Zoomer kids. I don't really get TikTok either, but it sure seems like people are relying on the features to actually change what they would have been doing, as opposed to something like Facebook, where if you post a video, it's probably just a video you took on your phone, didn't edit, and uploaded. That's at least what seems to be the trend to me.
Right. Yeah, and see here, actually, even the opinion itself, the opinion the Fifth Circuit issued that we're talking about, says the common carrier doctrine is a body of common law dating back long before the founding. It vests states with the power to impose non-discrimination obligations on communication and transportation providers that hold themselves out to serve all members of the public without individualized bargaining. I would say that's a very limited description of what constitutes a common carrier. So obviously, what the court does here is it focuses, and this has been the focus of a lot of jurisprudence pertaining to common carriers, but they focus on the fact that common carriers hold themselves open to the general public rather than negotiating with people on an individualized basis. So what that's focusing on is common carrier as opposed to contract carrier. So with a contract carrier, you're going to be drawing up an individualized contract with that company such that you now have privity of contract with that person. So, whatever the terms of that contract are, bind both parties. If that's true, then obviously whatever that carrier is undertaking is going to be that carrier's own speech, not your speech, is sort of where this division comes from. As the common law has evolved on the subject of common carriers, and people like telecom companies have been included in it, I think even things like amusement park rides, like Disneyland rides, have been included in common carriers because you all just line up in a line, you don't have individualized contracts, and you jump on the ride. If you get injured on the ride, well, then that wasn't an injury under your contract, that's an injury in which they're regarded as a common carrier. Okay, so here's what the judge actually has to say about common carriers. What they say is, by the time of the American founding, the duty to serve had crystallized into a key tenet of the common law. English courts applied this principle to numerous, quote-unquote, common callings, like stagecoaches, barges, grist mills, and innkeepers. And he cites Blackstone for that. Now, looking at that section in Blackstone, I'm actually familiar with it. He mentions basically the duty of innkeepers to safely keep people's property. Like if you leave a horse with an innkeeper, they have to make sure that it's safely held until you come back. That's what he's sort of talking about there. Anyway, judge goes on. He says, for example, Blackstone explained that that a public innkeeper offers an implied engagement to entertain all persons who travel that way, and upon this universal assumptuate, an action on the case will lie against him for damages, if he, without good reason, refuses to admit a traveler. In other words, because it's implicitly held open for all, there's an action for damages if he refuses to admit a traveler for whatever particular circumstances may be true about that traveler. Mm-hmm. Sir Matthew Hale explained regarding wharfs, when a private person builds only a wharf in a port, the wharf and crane and other conveniences are affected with a public interest, and they cease to be juris privati only. In other words, they aren't private property. They aren't the realm of private property only. Mm-hmm. The common law thus required a wharf owner to serve the public and not to impose discriminatory, unreasonable rates. So, I think that if this judge sort of, I don't want to be too critical of him, but it's sort of a unwieldy opinion. It's not terribly well organized. And I think that he's not properly identifying the legal issues at play here. Because the issue with these social media companies isn't just whether they will admit any kind of person to use their platform.
Yeah.
It's whether once that person has used the platform, they will continue to use that platform consistently with the terms of agreement the platform has imposed. Now, as far as I know, no social media platform, maybe I'm wrong here, maybe some have, but as far as I know, no social media platform has kicked somebody off for things they said extrinsically to that platform. Maybe somebody went out into the public square and they shouted obscenities at everybody. I don't think that happens and Twitter says, we're not going to allow you on the website anymore. I think typically they kick you off for things that you say on Twitter.
Yeah.
Which is where these analogies from the old common law, about innkeepers, wharf keepers, so on and so forth, fundamentally don't work.
Yeah. Because, it seems to me like the analogy would be closer to you went to an inn and you got in bed with your muddy boots still on and they were like, hey, don't do that. Get out of here. Rather than they saw you with muddy boots and they were like, no, you can't come in at all.
Yeah, exactly. Yeah, that's exactly right. Or maybe someone's just sort of an obnoxious loudmouth. And that person comes to the inn, asks for a room, innkeeper gives him a room, and the person goes up to his room and immediately starts shouting through the very thin walls, disrupting the sleep of all the other people who are staying at that inn.
Yeah.
Pretty sure that person's going to get kicked out. They're not getting kicked out because they're an obnoxious loudmouth. They're getting kicked out because they violated an implicit term of staying at that inn.
Yeah.
Now, what I'm not saying, people may hear me saying this, but I'm not saying this. I'm not saying that social media companies do have a right to impose whatever their terms of service may be. I'm merely talking about problems in applying the common carrier doctrine.
Yeah. Yeah, which, as we've mentioned, is not the only issue. It would certainly probably clarify parts of the argument, but resolving that question doesn't necessarily resolve the entire issue. There was one thing I noticed in this opinion, and it just struck me as so off base that I feel like I must be missing something, so maybe you can help clarify this for me. I think it's just wrong, but maybe there's something important I'm missing. The judge who wrote the opinion argued that if we grant the logic that the social media companies who are challenging this law follow, then, quote, email providers, mobile phone companies, and banks could cancel the accounts of anyone who sends an email, makes a phone call, or spends money in support of a disfavored political party. So in other words, Bank of America could be like, we see that you donated to the Democrats or donated to the Republicans, and we don't like that.
Sure.
So cancel the account. That just seems very
except that what they're
wrong.
ignoring here is that banks are bound by whatever contract terms they put in place when you open that account.
Yeah.
And if there aren't contract terms saying that your account can be canceled for certain kinds of expressions, then your account can't be canceled. I'd also say the difference is that social media companies do nothing but republish speech.
Yeah.
Right? I mean, bank accounts, you keep your money in a bank account. Your money can be speech, but your money has many other uses as well.
Yeah.
Social media companies do nothing but republish speech. So what they're arguing is they have a direct interest in terms of how they run their business in policing the content that's published there. I'm not saying whether I agree or disagree with that. Sorry, what, David?
I just said that's interesting. I hadn't considered that, but you're right. Yeah, your business is what people will see when they go to your website. You're right. That doesn't, sort of dispose of the issue, but that's important to consider, I think.
Yeah, well, and I think that, that's probably both the strongest argument for regarding social media companies as common carriers, and also the strongest argument against regarding social media companies as common carriers. Because if all they're doing is republishing speech people have already made, well, that sounds a lot like a common carrier. They're kept open to everybody, regardless of what your individual terms of contract are with them. And all they do is just move something from one place to another. In this case, from my computer screen to your computer screen.
Yeah.
That sounds like a common carrier to me, right? I mean, that
Sure.
sounds like the sort of thing that a common carrier does. It's also the strongest argument against regarding them as common carriers because their entire business model is picking and choosing which things to republish, which things to prioritize, which things the algorithm is going to say are important versus which things are going to say are unimportant. Debatably, the only difference between Facebook and Twitter is that algorithm prioritizing content, right?
Yeah, I mean,
There
are
there's
exceptions,
differences
but
in terms of what you can publish and what the format allows you to put up. But functionally speaking, the difference is in what you're shown.
right.
Me as a user of one of those platforms, what accounts for the difference of what I see when I pull open that app or pull up that website is that algorithm. So that's the service that's being provided, is censorship, essentially, right? Because we're showing people some ideas and we're not showing them others.
Yeah.
It's like I have a right to free passage between states, right? Like I can go to Nevada, I can go to Arizona, I can go to Wisconsin, I can go wherever, right?
Yeah.
If I go to an airline and I get on an airplane that's headed for the Atlanta airport, my rights are not being violated that it doesn't take me to Wisconsin.
Yeah.
That's the service that it's providing, is taking you to one place and not another place. The service that Facebook, Twitter, all the rest of them are providing is showing you some content and not other content. So I would say, where the common carrier argument succeeds is in the requirement for transparency in what the algorithms do on these websites, how they pick which content they're going to censor and which content they're not going to censor. I think where it fails is insofar as it targets the entire business model of these companies.
Yeah. Yeah, because if Twitter were nothing but people posting pictures of their cat's litter box, right? Probably not a lot of people want to use Twitter at that point, right? Not everyone wants to see that. So you might introduce a rule saying, hey, no more pictures of litter boxes, guys. Come on.
Well, Twitter wants to prioritize stuff that people find interesting.
Yeah.
They want that stuff to go higher up in people's, do they call it a news feed on that? I don't know. That's what they call it on Facebook.
I forget what they call timeline. Timeline is what they call it. Yeah.
Yeah, they want the interesting stuff to be republished, posted more times than stuff that is less interesting. That is inherently discriminatory.
Yeah. Yep.
That's also the business model.
Yeah. So anyway, we should probably move on from this, but think it is an interesting case in terms of some questions that come up, and I think it's very likely to end up before the Supreme Court. I basically don't see a situation where this doesn't end up getting some kind
event.
of input.
Yeah, once you get a circuit split. So once you get another circuit saying they're not common carriers, I think this inevitably ends up in front of the Supreme Court.
Yeah. So we will probably have occasion at least one more time to come back to this, but for now.
And Florida is in a different circuit.
Yeah.
So depending how that one comes out, I think likely this is going to get in front of the Supreme Court in the near future.
Yeah. All right. So the other thing that I wanted to talk about in particular, not because this is a necessarily like a current issue, it's just something I keep seeing crop up now in the news very frequently. It's sort of one of those things where the media narrative around a story actually sort of is the story, but people keep talking about this crisis of public faith in the Supreme Court, and what are we going to do about the legitimacy of the court if it's not perceived as trustworthy by the public? One of the things that keeps coming up in this context is the idea that we can restore faith in the court by, among other things, and I'll get into this in a second because this drives me crazy, because they almost always say imposing term limits on the Supreme Court. Now, that irritates me because what they actually mean is just imposing terms. A term limit is a limit to the number of terms you can serve. Like there's a term limit of 2 for the president. The term is 4 years. So that's me nitpicking, but it drives me crazy. I keep seeing that over the time. They want a term for the Supreme Court. Anyway, so next time you hear someone talk about wanting term limits for the Supreme Court, you get to feel like a smart person and tell them, no, what you're talking about is terms. But
yeah. Well, I think the reason they do that, the reason they put the conversation that way is that term limits tend to be popular for whatever reason. I think they're not a great idea, even in Congress, because what you end up doing is you give a great deal of power to unelected bureaucrats, since they're the only permanent people in government, where if a legislator's doing a good job, you should want to keep them in.
Yeah.
That's sort of the reason why we have people reelected. I know there's a huge incumbent advantage. Let's do something about the incumbent advantage, rather than just saying, throw the good out with the bad, baby out with the bathwater. But the reason they refer to it as term limits with the Supreme Court is I think they're trying to bias the conversation. We have limited terms to everybody else. Why wouldn't we want it for the Supreme Court? Well, I think there's any number of reasons for that, one of which we've talked about a great deal on this show, which is that we do not want the Supreme Court to become another political branch of government.
And that's, I think, the number one problem I have with this is if you associate the sort of ordinary business of politics with appointments to the Supreme Court, which they're already, I think, overly identified at this point. It becomes like a major talking point in every presidential campaign, basically. It's like, oh, who are they going to appoint to the Supreme Court? If we make it on like a rolling basis where a justice gets replaced every few years, typically the number I see people talking about is 18 years. So you would basically get a new justice.
That's such a strange term.
I think the idea is that it's so that every other year, one of the 9 gets replaced.
Okay.
I assume that's the reason.
Huh.
But that's sort of an arbitrary decision anyway. But
yeah, assuming no one ever retires or dies.
And so you'd get it every time there's a new Congress, you'd also get a new justice. And I think that would just over-identify that even worse than it already has been.
Yeah.
Where, rollovers in Congress go with rollovers in the justice. And I think you'd practically get judges campaigning on partisan tickets at that point. I don't see a way you wouldn't get that kind of overlap, which I think is just very unhealthy.
I think you're right. Yeah. Well, and some state Supreme Courts do it that way. And their Supreme Courts are basically political bodies as a result of that.
Yeah.
I mean, we have test cases to show you exactly how that goes. It certainly doesn't make them less political, which is the ostensible goal of people that want term limit or terms for the Supreme Court, right? They say that the court's gotten too political, I guess because in recent years Republicans have appointed too many of them. And the way to combat this is to make it an overtly political process. That just makes no sense to me. And not only does it not make any sense, we've got test cases in other states showing that is not going to work.
Yeah, and I think increasingly you're getting that for sure. I think that's sort of the mainstream dialogue around all of this is how do we make it less political? But then I think there is another rising faction that says not only should it be political, we just shouldn't have it because politics should be the only thing that determines. We mentioned that on
We've talked about that before
Kangaroo
on the show.
Court. Yeah.
Yeah, that's a good segue into Captain Kangaroo Court. Because they want us to have a Kangaroo Court if they're asking us to do that. But really, I think what imposing terms does is it does not create a less political Supreme Court. Whether it creates a more political Supreme Court, I think it does. But I think that's the less important part of what it does. Rather, what it actually does is it creates a Supreme Court that is subject to political change. Yeah. So change in the political disposition of the public. I think that's a worse thing. Because the one thing you really don't want a court to do is waffle back and forth between opinions. Much better to have it have consistently bad opinions than one that's switching its opinions every couple of years. No, it really is. That's genuinely true.
Because as we've talked about this before too, but one of the main values that you hope to have in a legal system is stability. And stability comes with predictability. And if precedent is constantly swinging, which it would if you have massive turnover in the court, you'd get new voices all the time, none of whom are going to perfectly align. Yeah, it's hard to see a way you keep a stable legal system that way. And we are sort of pressed for time, so we probably don't have a lot left to talk about this. But one thing I did want to mention, because this is one of the things I've heard several times, is, back when the Supreme Court system was designed with lifetime appointments, people didn't expect judges to last very long because people died younger. There's all kinds of reasons that's stupid.
Well, I mean, but not really.
Yeah, I know. People always forget to factor in infant mortality when they talk about historic lifespans.
And death in childbirth.
Yeah, and violent death, all kinds of stuff. Yeah. But I decided to...
We've medical science... What medical science has managed to prevent is a lot of the unexpected death that people would experience. So like death in childbirth, death from various medical conditions. Yep. People that didn't die from some kind of medical condition lived about as long as they do now.
Yep. Anyway, I chose to deal with this empirically, though, and I looked up a chart of Supreme Court term lengths. I have the top 20 up here. You'll note that 9 of the top 20 are from the 1800s. And most of the others are like...
This is how long they served on the court?
Yeah. Most of the others ended rather in the mid-20th century. So
yeah,
very few of the longest serving justices are from the recent past at all.
That's a clever to look that up.
Yeah. Nearly half of them were from more than a century ago. So
which makes a lot of sense too, because we've pushed the ability to acquire advanced degrees and move up in positions of prominence is something that we've pushed older and older over the past century. You know, we required more and more qualifications and certifications to get to high-level positions like being a Supreme Court justice. So people are starting the job older.
Yeah. Yeah. You know, it's granted not exactly transferable, but in my field, there's famously one of America's great theologians, Jonathan Edwards, graduated from Yale at 14 because he demonstrated sufficient knowledge of Greek, Hebrew, and Latin. And that's what it took. It was just, you can show you've got this, you get a degree. So he did it.
Good luck doing that nowadays.
Yeah.
You got to jump through all the hoops regardless of what you know.
Yeah. So anyway, but I that's another one to keep in your back pocket.
Make that the picture for this podcast episode. We can do episode pictures. Just do that so people can see the list.
Okay.
I think it's worth seeing.
Yeah. Anyway, so we'll make that list available. But yeah, I thought that it rung false, and indeed it is false. So
yeah.
Anyway.
Well, it's a silly thing to say. I don't know why people think that lifespans are so much longer now. I mean, you look at average life expectancy, sure.
Yeah.
But that's including catastrophic death.
Exactly. And it's... Yeah, you get stories about people living into their 70s, their 80s from thousands of years ago. It's not that the natural lifespan has changed. It's just that we're better
Benjamin Franklin died at 84.
Yeah, we're better at not dying from accidents, disease, and violence, basically.
Yeah, Thomas Jefferson, I think, died at 83. People died in their 80s back then.
Yeah, if not, sometimes older than that.
I think, how old was Adams? I think Adams was 90 when he died, the same day as Thomas Jefferson, within hours.
Yep, that's right.
I think he was 90 when he died. I'm not just picking the people who lived the longest of the founding fathers. I'm picking the ones whose ages at death I happen to know offhand.
Right. Yeah.
So,
anyway, and there's a further irony to me too, in that one of the things that sort of precipitated this alleged crisis of confidence in the court is that people said, "Oh, they're not abiding by this precedent that was set in a recent case." We alluded to this, but there's no better way to guarantee precedent won't last and won't be followed than to have massive turnover in the court. You're just all but guaranteeing it. So
yeah, I mean, it's as a matter of human disposition, the same people are more likely to keep the same opinions than different people.
Yeah, and this is all, we're sort of circling around the fundamental point. But the fundamental point is you want the justices not to be subject to political pressure. That's the whole point of the institution in the Constitution, is that it's insulated from the tides of political opinion, because you're trying to get reasoned, consistent judgments about what is and is not law.
Which is very hard to do if there are a lot of people pressuring you.
Exactly. Anyway, we probably have run too late again, so
we've only got a couple minutes, but we still do have time for everybody's favorite section of this podcast. So come around, young and old, boys and girls, people of every age, anyone interested in American law or law across the globe and through the ages, join us for Captain Kangaroo Court. All right, so this is another episode of Captain Kangaroo Court.
Yeah.
I don't have anything planned for us today, David. Do you have anything to look at?
I have some things, and to keep it quick and punchy, I'll just give you two. And there's a theme here, as it turns out. There wasn't going to be a theme, but it's attorneys who get into some trouble and their odd possessions. So we're going to start with a little story about, I think you're familiar with Tom Girardi.
Yeah. Yeah.
So
I am familiar with Tom Girardi.
He was recently disbarred, but a fairly well-known attorney from California, and
he was pretty well regarded before it turned out that he was kind of siphoning money out of all of his client trust accounts, which is about the worst thing you could do as a lawyer. I mean, you really got to be careful with those client trust accounts.
Yep.
I don't know how he got away with that for as long as he did. If most lawyers I know, if they did that for a week, they'd be caught and disbarred the next week.
Yeah.
But he got away with it for decades somehow. That's about the worst thing you can do. as a lawyer, just in all honesty.
Well, and it's one of those things where, like, if this were about like a big drug dealer being busted, I think you'd expect a similar story. But he was found guilty of embezzlement of client funds, basically, and among the things that happens as a result of that, they're auctioning off his stuff to try to raise the money to make some of those clients whole. So here are some things that were auctioned off.
They filed for bankruptcy.
Yeah. Mm-hmm. Here were some things.
They're auctioning off the bankruptcy estate
so
that they can pay back the clients to whatever extent they're able.
Yeah. So here's some things that he had that were auctioned off. A basketball signed by Michael Jordan. Boxing gloves.
I think he represented Michael Jordan, didn't he?
Did he? I don't know that story, but that's interesting if so. Boxing gloves signed by former professional boxers George Foreman and Joe Frazier. I don't know if you are a boxing fan or anyone in the audience is a boxing fan, but those are big, big, big names in the world of boxing.
Oh, yeah. I mean, one of them made that grill that they advertised on TV for years and years.
That's true.
He's got to be big.
Yeah, and that Hank Hill refused to sell. Because it
didn't run on propane.
It was a novelty grill because it didn't run on gas.
Yeah.
Albums signed by singers Kenny Rogers and Christopher Cross, who, I don't know if that's his real name, but it always struck me as ironic if it is his real name, but his name is Chris Cross. But a WrestleMania 2000 towel signed by former professional wrestler Dwayne "The Rock" Johnson. And this is my favorite, a holographic Pokemon card featuring Charizard. I love the way
One
they
of these
phrase
things
that.
is not like the others.
I love the way they phrase that too. Featuring Charizard.
so then Tom Girardi collected Pokemon cards, evidently.
Evidently, or bought one for a child that he then took away from them because they displeased him, or
We've had other people on this podcast getting in trouble for their exploits relating to Pokemon, haven't we?
That's true. Yeah,
those police officers that didn't respond to a call because they were too busy
playing
catching Pokemon in Pokemon Go.
That's right. They in fact fled the scene of a crime in order to keep playing Pokemon Go.
Boy, I guess you really do got to catch them all.
Yeah. And in this case, you gotta sell them all too, I guess.
That's good.
All right.
So have those been auctioned off yet, David?
Yes. So apparently.
So you're too late for the bankruptcy estate auction. So
yeah, they reported that
if you were really interested in that Charizard card, I'm afraid you're too late.
They reported that 100% of the items up for auction were sold, and it raised about $500,000 apparently.
Usually 100% is sold because that's the whole point.
Yeah.
You can generally get pretty good prices on things. You go to bankruptcy auctions.
That makes sense.
My family's practice, Haberbush LLP, is a bankruptcy debtor-creditor relation firm. You can't go to these auctions if you're a lawyer representing any of the parties in one of these bankruptcies.
That makes sense, yeah.
That's been a huge disappointment to me on many occasions because there's been a lot of stuff that I don't want at these bankruptcy auctions. Seriously, watch bankruptcy auctions. You can get some good stuff.
Yeah. Dang. Ethical rules from the bar.
I know, right? I have to follow them. I'm like Tom Girardi.
Anyway, but this put me in mind of another story that I remembered, and this was from more than a decade ago at this point. I think 2008, and you might remember this as well. But there was a Texas DA who ultimately was convicted. I think not just for this, but for other things as well. Because I found a story later about him being paroled, but. Well, I'll just read the header and subhead here. This is from Wired.com. Texas DA on trial for gimmicky computer purchase. Subheader says, Rockwall County, Texas District Attorney Ray Sumrow is being tried on charges of forgery, theft, and records tampering after he used state funds to buy a high-end gaming computer. The computer, he claimed, was used as a backup server. And then they go on to say, the presence of large amounts of personal data as well as gamer-specific customizations, including, and then this is the part that really got me, 2 hard drives, 7 fans, high-end video and audio cards, wireless internet connection, and cables that glow under ultraviolet light.
What was this for? This was all for his...
He claimed it was a backup server. But it sure sounds...
But it sounds like a gaming computer.
It sure sounds like a gamer rig to me. I don't know.
What? Yeah, I mean, I've indulged in some gaming in my day, and I've built gaming computers myself. And that, honestly, I never go for the ultraviolet cables.
Yeah, some of it
And
isn't. That's my favorite part, is that some of it isn't even actually about like the performance. It's just sort of aesthetic stuff.
RGB stuff.
Yeah. So he's got like the neon glowing cables. 7 fans. That's aggressive too.
Cooling's very important in gaming systems.
Yeah,
you want to have a lot of airflow. Maybe he was into overclocking.
Yeah, no, it sure sounds like it, and I'm not sure what percentage of the audience is.
I bet he pwned a lot of noobs on his backup server.
I'm not sure how many people in the audience are, into that world, but yeah.
So he purchased this whole thing on public funds, then.
Yes, and
wow,
then,
that's.
Yeah, so all that to say, if you're going to embezzle funds, and I feel like we can safely say you shouldn't. Not just on as legal advice. It's not legal advice technically.
Moral advice as
Moral
well.
advice, yeah. And just sort of general...
Don't embezzle people's money.
Yeah, general life advice, I guess. But if you're going to do it, probably don't just buy conspicuously high-ticket items that you keep around.
Yeah, well, servers are expensive, so...
Yeah.
But that's not a server. Gaming hardware is very different from server hardware.
Yeah. So anyway, that's all I've got for this week.
All right, folks. So hopefully you all enjoyed this week's foray into the always interesting and always wacky world of Captain Kangaroo Court. Please join us again next week, and see you folks all again then. But yeah, it's been a presentation of Captain Kangaroo Court.
Yep, and that'll do it for this episode. So as always, thank you for listening, and we hope that you'll listen again.
Yeah, thank you very much.
See ya.